Section 48 states that a patentee or a patent restored in terms of Section 47 shall not institute any proceedings against or recover damages from any person who infringed the patent after the lapse of a period of 6 months from the date on which the renewal fee was due and before the date on which the application for the restoration of the patent was advertised. So you cannot institute infringement proceedings and recover damages where somebody would otherwise have infringed that patent had it been in effect. You also cannot institute proceedings or recover damages against any party that used, offered to dispose of, or disposed of any article made or imported in that period referred to in paragraph A. You then also cannot institute proceedings or recover damages from any person who during that same period commenced using or exercising the invention to which the patent relates, and who thereafter continues to use or exercise the invention, use or offers to dispose of the invention, or disposes of any articles or products produced by the continued use or exercise. So if somebody has set up shop to utilize that invention, well, sorry for you, you can't institute infringement proceedings had they done so whilst the patent had lapsed. And even after it's restored, you cannot pursue them for infringement or recover damages. So it's very important to ensure that you do not allow the patent to lapse, because your rights are quite restricted then. Then it gets even worse for the patentee. Where a patent has been restored, any person who during that period has expended any money, time, or labor with a view of making, using, exercising, offering to dispose of, disposing of, or importing the invention may apply to the Commissioner for compensation in respect of the money, time, and labor so expended. So you, as that third party, can now sue the patentee for any money, labor, or time that you have expended in utilizing that invention. The Commissioner may, after hearing the parties concerned, assess the amount of such compensation, if in his opinion the application ought to be granted, and determine the time within which such compensation shall be paid. So quite a harsh penalty if you allow patents to lapse. Question?
So section C, it says that the patentee can't institute any proceedings or recover damages for people that started using the invention and then continue to use the invention. Why is section 2 there? Because the person can continue to use the invention. So
I also don't know, to be honest with you. It's like a catch-all provision. I don't know why there is, because it doesn't make sense to me either. Sorry, I don't have a better answer than that.
Where does it say after?
Well, it says who thereafter continues to use or exercise the invention. Yeah. The other thing that might come into what you were asking earlier is that with C, it's limited to use or exercise. It's not limited to importation or disposing or offering to dispose of. So those are different acts of infringement. So maybe that is why there is then that distinction between this provision and subsection 2. Because if you have a look at subsection 2, it refers to all the acts of infringement: making, using, exercising, offering to dispose of, disposing of, or importing. So it's broader in this sense.
So you can only need to use the patent. You can't
You can't import the product. You also can't advertise the product, because that's what offering to dispose of. It's basically marketing. You can't market any longer.
See, it's confusing. But it's referring to the same subpart of one kind. Instead of the same.
Let me read through carefully. So commenced using or exercising the invention to which the patent relates, and who thereafter continues to use or exercise the invention, uses or offers to dispose of the invention of any article. Yeah, you see, it's only importation that's excluded.
See, it's still referring
Yeah,
to
dispose. But it says who thereafter continues. So who thereafter continues would be after the restoration of the patent. Because it says a patentee of a patent restored shall not institute proceedings or recover damages. So the patent's been restored. And then if you look at C, thereafter continues. So if you read it as one continuous sentence, it's after the restoration continues. We'll have a closer look. Okay. Yeah. It's only the importation that's excluded in subsection C. Okay. Then, if we move on to revocation, revocation is relatively straightforward in that there is a defined list of grounds on which a patent can be revoked. And these grounds of revocation are set out in section 61, subsection 1 of the Patents Act. I encourage you to know all these grounds on which a patent can be revoked. I've already mentioned a few throughout the course of yesterday and today. You can tell me one. There's one more prize left. Tell me one instance in which the patent can be revoked. You already got a prize. Okay, the lady in the back. Yeah, straightforward. Yeah. Was it that difficult? Okay, so section 61 says any person at any time, just a distinction between a compulsory license, revocation, who can bring those applications. For a compulsory license, it says any interested person. They must have an interest in that patent. Whereas with revocation, it says any person. So anyone can attack the patent's validity. So any person may at any time apply in the prescribed manner for the revocation of a patent on any of the following grounds only. So there's no need to show any particular interest, as with compulsory license. The application for revocation may be brought at any time from the date of grant of the patent up to the date of expiry thereof, or even after the patent has expired. As I've said, the list of grounds are exhaustive, and this was confirmed in the Busby versus Registrar of Victoria of Patents case, where the court said you cannot create other grounds on which the patent can be revoked. It's only those that are provided for in section 61.1. You can rely on any one or more grounds when revoking a patent. So you can revoke the patent based on the invention not being novel. You can also simultaneously argue that it is not inventive. You can also rely on the ground that the declaration on the form P3 is false. So you can rely on multiple ones. That gives you a greater chance of success. So if one of those grounds fails, you can rely on one of the other grounds on which to invalidate the patent. It's also important to note that if I, as the patentee, institute infringement proceedings, so where somebody is performing one of the acts of infringement over my invention, that party can then counterclaim for the revocation of the patent. So if I say that party X, you are copying my patent, I'm suing you for infringement of my patent. He can then say, party X, well, your patent isn't actually valid because it lacks novelty, so I'm not really infringing. So they can, in infringement proceedings, counterclaim for the revocation of the patent. So when you institute infringement proceedings, you better well be sure that your patent is actually valid. Otherwise, they're definitely going to counterclaim for the revocation of your patents to act as a defense against the infringement proceedings. Okay, so what are the grounds of revocation? The first is that the patentee is not a person entitled under section 27 to apply for the patent. Who's entitled to apply for the patent? No prizes, sorry. Okay. Inventor and assignee. Okay, excellent. Right. Then, that the grant of the patent is in fraud of rights of the applicant or any person under or through whom he claims. So this is where the alleged patentee construed conduct that was deliberately designed to deprive the patentee or the rightful owner of those rights. So they committed some form of fraud in order to obtain the patent rights. Then moving on, and probably the provision that is most readily relied upon in revocation proceedings, is that the invention concerned is not patentable under section 25, which the lady at the back mentioned. It's not just novelty and inventiveness. It's not patentable under section 25. That is novelty. That is inventiveness. Okay. Utility. What else? Okay, we said inventiveness.
It is an invention.
Yeah. Okay, so exactly. If it's not an invention, if it's an exclusion from being an invention, if it's a discovery. What about 2511? Who knows it? Method of treatments. Also, okay. So many provisions in terms of section 25. Guys, this is important. If I ask you in the exam to state what the section or the grounds of section 25 on which a patent can be revoked, you need to be able to spew it out. Okay. Don't look so stressed, guys. Okay, the next is that the invention as illustrated or exemplified in the specification concerned cannot be performed or does not lead to results and advantages set out in the complete specification. So I spoke about this yesterday as well. You do not provide enough information for somebody skilled in the arts to actually perform that invention, or does not lead to results and advantages set out in the specification. So again, very important if you are the patent attorney drafting the specification to be very careful what you are stating the advantage of this invention is. Because if it doesn't meet that advantage, the patent can be revoked. Then that the complete specification concerned does not sufficiently describe, ascertain, and where necessary, illustrate or exemplify the invention in a manner which is to be performed in order to enable the invention to be carried out by a person skilled in the art. Okay, so this is insufficiency. So D, we refer to as inutility, which relates to the description of the invention, not the invention as claimed. So you cannot perform the invention based on the description, and it does not lead to the results and advantages. Whereas with E, which is insufficiency, it's a question of fact, because can a person that is skilled in that art actually perform the invention? Does it enable them to execute the invention that is disclosed in the complete specification? Okay, so inutility, it doesn't actually work. With E, there's not sufficient information provided to make it work, to get the same results. All right, then F, that the claims of the complete specification concerned are not clear, so they're vague, they don't actually clearly define what you are protecting, and that they are not fairly based on matter disclosed in the specification. One that I've harped on about quite at length is that the prescribed declarations lodged in respect of the application for the patent, so that is the form P3, or the statements lodged in terms of section 30, subsection 3A, which is your form P26 that relates to indigenous biological genetic resources traditional use, contains a false statement or representation which is material and which the patentee knew, and as I said this morning, or ought reasonably to have known to be false at the time when the statement or the representation was made. And there you'll see I have the citation of the Benz case, which we discussed yesterday, where we used the US applications as an example, where they were not claiming priority from the first filed application, because the form P3 states that I'm claiming priority from the first filed application in respect of that invention. Then moving on, that the application for the patent should have been refused in terms of section 36. That is that the invention is frivolous on the ground that it claims an invention which is obviously contrary to well-established natural laws, encourages offensive or immoral behavior, or is related to nuclear energy. Okay, that is something that I haven't touched on, is the nuclear energy requirement. When an invention relates to nuclear energy, the technology relates to nuclear energy, the Nuclear Energy Act comes into play. There are additional requirements that need to be complied with when application relates to nuclear energy. That is, once you lodge the application, you need to notify the Department of Mineral Resources and Energy that you have submitted an application that is relating to nuclear energy. They need to assess that specification and claims themselves, so the Minister of Department of Mineral Resources and Energy, and they need to approve the further continuance of the prosecution of a nuclear-related application. Okay. Only then can the Patent Office formally examine the application and issue acceptance. And this has to do with the nuclear non-proliferation regimes and bilateral and international treaties when it comes to nuclear inventions. And we get these quite often. So I often have to write to the minister to inform them of this invention that is being filed in South Africa, and they consider it very thoroughly. They will write back to you stating that they consent to it based on X, Y, and Z. All right. So if you don't comply with those requirements, then it's also possible to revoke the patent. Then that the complete specification claims an invention as a microbiological process or a product thereof, and that the provisions of section 32.6 have not been complied with. So again, this is something that is new to you, being 32 subsection 6. In terms of section 32 subsection 6, where an invention relates to a microbiological process or product thereof, and there is an organism that is required to be used in performing that invention, that microorganism needs to be deposited at a facility that can preserve that microorganism. So they will culture it, they will continue to grow it, or they will cryopreserve it, and you will be granted an accession number. So that's the access code to be able to obtain that microorganism. Okay, this is in terms of the Budapest Treaty. So this might be the first time you're hearing this over the course of these 2 days. The Budapest Treaty provides for this accession where a microorganism can be deposited at an approved facility. You do, because how are you going to know what this ground of revocation then relates to? Okay. Yes.
All grounds, or you need like 5?
Depends on my mood. Depends on the mood. Guys, can I tell you, this is the easiest marks. It is really the easiest marks that you can get. There is always a revocation question. There is only so much I can ask on revocation. Okay, I can't ask you intricate group 2 questions for patent attorneys practice. I can't tread on their territory. So there's only so much I can ask. Get this in your heads. All right, easy marks. If I ask all of them and you don't get them, it's a fail outright. Joking. No, I'm not. Maybe that's my dream coming true, my nightmare. I'm just joking, guys. I can't be so cruel. Okay. Remember yesterday we said that a claim can relate to one invention only. We've also got the option to file divisional, and then I also said that there's no ground on which you can attack the patent if it comprises more than one invention. That's what's stipulated in section 62. So it says a patent shall be granted for one invention only. We know this, but no person may in any proceedings object to a patent on the ground that it comprises more than one invention. I don't even know why that prohibition is there if it doesn't actually mean anything. All right. Section 63, where a patent is revoked on the ground of fraud or patent fraudulently obtained has been surrendered and revoked, the commissioner may, on the application of the inventor of the relevant invention or his assignee, so on and so forth, direct the grant to the rightful proprietor. So if somebody fraudulently applied for the patent, if it is to be revoked on the ground that it was obtained in fraud of right, the commissioner can decide, instead of revoking the patent, I will grant the rights to the rightful owner of the invention. Okay. Section 64, you can have a look at, dealing with a voluntary surrender of a patent. So that is, if you as a patentee know your invention is invalid, it comes to light after it's granted, you can surrender it and nobody can institute proceedings against you. Any questions on revocation?
This is just combining the revocation and the amendment section. If you are taking to court for revocation, can you then do the legal amendments during the legal?
Yeah. So during any,
if you do like, but you contemplating reporting right, assuming you can't amend that.
No.
Maybe you do
no,
Swiss type instead of.
you can amend the specification in the claims. So if somebody tries to revoke the patent on the ground that it is not novel, so it lacks novelty, you can try and amend the claim to introduce the integer that's already claimed elsewhere to include that novel feature. But the problem is, if you do amend in legal proceedings, a third party can oppose it as well. So then it becomes a separate matter that the commissioner then has to first consider that amendment, whether they allow it or not. Then it will go back, once it's allowed or refused, back to the revocation proceedings. Okay. Okay, so we move on to infringement. So section 45 is an important section because it tells us what the rights of the patentee are. What is the right that is granted once the patent is published in the patent journal? It says the effects of a patent shall be to grant to the patentee in the Republic, subject to the provisions of this Act for the duration of the patent, so for 20 years, the right to exclude other persons from making, using, exercising, disposing, or offering to dispose of, or importing the invention, so that he or she shall have and enjoy the whole profit and advantage accruing by reason of the invention. So that is what the patentee can exclude other people from doing. They cannot make, they cannot import, they cannot use the invention, they cannot dispose of it, they cannot market or advertise it. Okay, otherwise they would be infringing. So this tells us the rights of the patentee to exclude others, and these also tell us what the acts of infringement are. So if another party manufactures it, that is an act of infringing. If they are importing the patented invention, they are infringing. Then section 45 subsection 2 says the disposal of a patented article by or on behalf of a patentee or his licensee shall, subject to the patent rights, give the purchaser the right to use, offer to dispose of, and dispose of that article. This is an exhaustion of rights. Once the patentee sells the article, purchaser of that article can deal with it in any way that they deem fits. The patentee's rights over that article are exhausted. Question?
Subsection C.
Yeah.
So if we consider subsection C in light of the infringement, what is the implication of like those two provisions being read together? Because with the lapse restoration of rights, we can still continue to dispose of the article.
Yeah.
And in section 5 says that infringement. So does that mean that?
Well, you won't be able to institute infringement. It specifically says that you cannot institute proceedings where you are continuing to dispose of that article. Because imagine now that you have manufactured during that lapse period, you've manufactured a whole bunch of articles. So you've stockpiled all these products. So you are still allowed to sell those products and get rid of them. That's where the gray area is coming in, because further on in that section, it says that you can continue to make. So it's a very complicated provision that, because it's not so clear cut. But the interpretation that I understand is that that party can continue to utilize it. They can continue to put into effect the invention. Well, you can prevent other people. Yeah. No, I get it. I get it. Yeah, I get it. It is limited. Okay, so who has locus stand up to then bring the infringement proceedings? The patentee, obviously, they're the right holder. A licensee that is recorded in the patent has no independent right to institute proceedings. Okay, but a patentee must give notice to every licensee recorded as such in the register, who is then entitled to intervene as a co-plaintiff. Okay, so that the licensee of that patent cannot institute proceedings on their own, but the patentee has to give notice to the licensee if they wish to institute proceedings, and they can then join in proceedings so that they can too recover any damages if there are, or any costs awarded. Okay, then how would the courts determine if there is an infringement? And this is again set out in the Ensign Bickford versus AECI Explosives and Chemicals. This case has come up before. Can you remember which case? There was another test that came from this case. Inventiveness. Hold on. Okay, so from inventiveness. So this test also comes from that same case. So it says that in order to ascertain whether there has been an infringement of a patent, one must decide if the act alleged to have been done by the defendants is of such a nature that it can constitute an infringement of the patent or is excusable. So has the alleged infringer performed one of the acts of infringement? So are they making, are they using, are they importing? And is there an excuse to what they are doing? Then similarly, when we looked at determining novelty, the claims for infringement, with this infringement proceeding, the claims would again be construed. So the court will then again break down the claims into their integers. Okay, what are the features that make up this invention? And they will then compare it to the alleged infringing article. If that alleged infringing article comprises all the integers, it is infringing the patent. Yeah. Then the court must also consider whether there is any valid defense that the defendant may have. So this step is similar to novelty. With novelty, you are comparing your invention, the claims of that invention, with prior art. In this instance, you're complaining the claims of your invention with an alleged infringing article. Okay, so the acts of infringement we now know are making, using, exercising. You can go through this. These are the dictionary definitions of what each of those words mean. So section 67 is then a presumption in relation to new substances, which I mentioned this morning. So where there is a claim in respect of the patent for a process or an apparatus for producing any product, then that patent protection is extended to the product of that process or apparatus. Okay. If the invention for which a patent is granted is a process for obtaining a new product, the same product produced by a person other than the patentee or licensee shall, unless the contrary is proven, or in any proceedings have been assumed to have been obtained by that process. So if it's the same product, so if there's the patentee and a third party, they have the same product, it is assumed that that third party's product was manufactured using the patented process. Okay. It is then the responsibility of that third party to discharge that onus. They then need to prove that my product was not obtained by the patented process. Okay, so what are the defenses to infringement? Well, the first is that there isn't any actual infringement of the patent. There's then the invalidity of the patent. So that is where you will counterclaim for the revocation of the patent. So that is the most common defense that is used, is that you will try and revoke the patent on one of the grounds of revocation. That there was a license granted. And then also that the rights of the patentee were exhausted. So just some of the defenses. So if it is found that a third party has infringed the patent, what are the remedies that the patentee can obtain? The first is an interdict. So to stop the infringer from continuing the acts of infringement. So it's a court order stopping them from conducting those acts. Or the delivery up of any infringing product. So if they have manufactured or they have imported products, they need to deliver it up. And if it forms part of an inseparable part of another product, they need to deliver up that entire product. You can then also request damages. Another remedy is that instead of damages, the patentee must be awarded an amount calculated on the basis of a reasonable royalty. So an assessment would have to be made. What would the patentee have been entitled to in terms of a reasonable royalty had they actually licensed that product to the infringer? Then another point, I mean, it's not legislated, but you mustn't forget to ask for your costs order, okay? This is a costly endeavor when you're instituting infringement proceedings. We had a case several years back when I was a candidate still for a card shuffler. That sounds arbitrary, but I mean, if you think about massive casinos across the world, thinking about your Monte casinos, Sun City, the casinos in Las Vegas, they all use very advanced card shufflers that are able to shuffle multiple decks of cards. And there was an infringement based on that card shuffler, which was patented in South Africa. And expert witnesses had to be flown in from Australia to testify in court to give their determination as to whether that invention was invented during the counterclaim for revocation. So imagine the costs involved. You're paying the expert witness, you're paying for their flights, you're paying for their accommodation. It becomes very costly. Okay. So remember to ask for your costs in your prayers. Okay, and we also now know that you can counterclaim for revocation. The partial validity in terms of Section 68 is relief for infringement of partial validity. So where in any proceedings for infringement of a patent, the Commissioner finds that any claim in the complete specification respect of which infringement is alleged is valid, but that any other claim therein is invalid. So in other words, where a patent has at least one valid and one invalid claim, the following provisions shall apply. So this goes back to the question that was asked earlier. So if it is found in infringement proceedings that there is novelty in one claim, but another claim lacks novelty, then in that instance, if there is a counterclaim for the revocation on the ground of that invalidity, the Commissioner may postpone the operation of any order issued upon that infringement to enable the patentee to effect any amendment of the specification pursuant to the conditions imposed by the Commissioner, who may attach such other condition to any order to be issued on the counterclaim as he may deem fit. So where one claim is found to be invalid and infringed, and another claim is found valid and not infringed, the court can give the patentee the opportunity to remedy the patent to ensure that it is an enforceable patent right. But when the specification has been amended in terms of the prior provision to overcome the invalidity in the patent claims, the Commissioner may the Commissioner may subject to such order as to costs as he may issue, and as to the date from which damages shall be calculated, grant relief in respect of any claim which had before the amendment been found to be valid and infringed, and in exercising his discretion, he may take into consideration the conduct of the patentee in inserting the specification, those claims which had been found before the amendment to be invalid, or permitting such claims to remain there. Okay, so quite a lot going on in this section of the Act. So if there is an instance where there is an invalid claim that is being infringed, or a valid claim that is being infringed, and others are valid and not infringed, then the court can award damages based on only the valid claims that are infringed in the specification. The court will also consider the costs that are being awarded for damages. So was the patentee aware of an invalidity in that patent and they didn't act on it? If they were aware of that invalidity and they didn't act on it, the court is not going to act in the patentee's favor. You're not going to get your costs or damages awarded to you. Okay? So they might try and preserve the patent, but you might not be successful in obtaining costs or damages awards in such a proceeding. Okay. And there is case law on this as well. It's a Lundbeck case. What had happened with the Lundbeck case was they had claimed a specific enantiomer of a compound, but it was the incorrect enantiomer that they claimed. It was a clerical error. They had filed this application, or they had filed applications across multiple jurisdictions for that invention. The South African application with the incorrect enantiomer that was being claimed, that arose due to a clerical error, went to grant quite quickly because there's no examination in South Africa for substantive requirements. Whilst many other of the applications were still pending. So Lundbeck, the pharmaceutical company, then proceeded to correct the issue in the other applications. But they had somehow forgotten to correct the South African patent. In the 19th year of the life of that Lundbeck patent in South Africa, somebody brought in, or they tried to bring, infringement proceedings, and they tried to remedy the clerical error before the courts at that stage. So many years had passed when Lundbeck was aware of the error in all their other applications. The South African one, they did nothing about. The court did not act favorably upon Lundbeck. Okay. So that is what we refer to when the court must consider the conduct of the patentee. Section 69, you can have a look through in your own time. Section 69, capital A, are acts of non-infringement. Okay, so these are acts which would otherwise be considered an infringing act, but in this instance, they are excused. And this is what is known as the Bolar provision, which arose from a case in the United States, which was the Bolar case. And this section says that it shall not be an act of infringement of a patent to make, use, exercise, offer to dispose of, or import the patented invention on a non-commercial scale and solely for the purposes reasonably related to the obtaining, development, and submission of information required under any law that regulates the manufacture, production, distribution, use, or sale of any product. Can anyone tell me where this would be applicable? To the lady in the back. But you're disclosing it yourself as a patentee. This is if it's a third party that's performing one of these acts.
Like when you like a store, so company.
Lucia, you touched on this yesterday. Think back. Think Myprodol, think Genpain. Generics. That's what this is permitting. It is not an act of an infringement for a generic pharmaceutical company to import or to use the patented product in order to submit information to a regulatory body. Okay, so if you go through, it shall not be an act of infringement if on a non-commercial scale, you are using the invention solely for the purposes reasonably related to obtaining, developing, and submitting of information required under any law that regulates the manufacture, production, distribution, use, or sale of any product. Remember, for pharmaceutical to hit the market, you have to obtain approval from SAHPRA. So to speed up that process, so as soon as the patent expires, the following day, the generic pharmaceutical can hit the market. Why isn't it? The patent's expired. But is that not against public interest? Because the generic is far cheaper, it's greater access to medicine. So this provision is in public interest. Anyone else? Other views? Okay. So this is purely directed towards access to medicine, okay, for public interest. Okay. just for interest's sake, some countries permit for patent term extension. Okay, so we know patent is for 20 years. Some countries permit you to extend that monopoly by 3 years or 5 years, depending on their legislation. South Africa doesn't have that provision. The reason why some countries permit that is if you think about pharmaceutical products. Pharmaceutical products take incredibly long to develop. They're incredibly costly to develop. And research indicates that the pharmaceutical companies only start making a profit on that product within the 17th or 18th year of the life of the patent. So everything else is basically covering the costs to develop that pharmaceutical. So they then only have 2 to 3 year period within which to make any profits. So some countries then permit a patent term extension, also because a lot of the times these products, the patented products, cannot reach the market until the regulatory approval has been obtained for to enter the market. That can also be a very, it can delay the period within which the patentee can obtain the just reward from the patented invention. Okay, so that's why some countries have patent term extension. Then
Sorry.
subsection, yes.
I must have maybe misconstrued or misunderstood you. This particular provision, does it apply during the subsistence of the patent or once it is expired? I thought I heard you saying once a patent expires, you said generic pharmaceuticals can flood the market based on this 69(1).
Okay,
Did I misunderstand?
Ask yourself the question, would they be infringing if the patent expired?
Yes, obviously not. That's why I'm asking.
Yeah.
Yes.
So this is specifically to resume with the regulatory approvals and to develop the patented product during the life of the patent. So it's before the expiry of the patent. Okay, then subsection 2 says it shall not be permitted to possess the patented invention made, used, or imported or acquired in terms of section 1 for any purpose other than for obtaining, development, or submission of information as contemplated in that subsection. So you can only possess that invention for the purpose of what it is intended for, and that intention is to obtain, develop, or submit information. So you cannot, as a generic pharmaceutical manufacturer in this example, stockpile. You cannot buy shiploads of the products and then sell it once it expires. You cannot do that, okay? So whatever you buy, it has to be for those purposes. Then we come to threats of infringement, which is in terms of section 71, where there is a remedy for groundless threats of infringement proceedings. So if you, as the patentee, allege that a third party is infringing your patent, and it is groundless, it's a groundless basis, you're just using this patent to scare somebody, it is groundless, then that party has a remedy against you as a patentee. Okay, so where any person threatens any other person with proceedings for infringement of a patent, a person aggrieved may, whether the person making the threats is or is not entitled to or interested in the patent or an application for a patent, institute proceedings against him and obtain a declaration to the effect that such threats are unjustifiable. So you can approach the court and tell the court, the patentee is threatening me with infringement, but the grounds on which they are relying or the basis on which they're relying is groundless, and you want a declaration that that is unjustifiable. You can also obtain an interdict against the patentee if they continue, so that they don't continue with threats of infringement. And you may also recover damages if there are any damages sustained, unless the person making the threats proves the acts in respect of which the proceedings are threatened constitutes, or if done, would constitute an infringement of a patent in respect of the specification. So you have to be very careful if a client approaches you and says, somebody's copying my patent, they're infringing my patent rights, send them a letter of demand. You need to be sure that when you are alleging infringement, that there is a likelihood that they are indeed infringing. Okay. Otherwise, they can have recourse against you in terms of section 70, subsection 1. Okay. Evidence, as you can see, there's no information there. Self-study. Appeals to the commission and the court. Again, let's leave that for self-study. Offences and penalties, some things to just be aware of. I'm not going to go into this in much detail, but there are certain criminal acts in terms of the Patents Act. So if you're alleged to be an employee of the Patent Office, then you're not. That is one. If there is insider undertakings within the Patent Office, that official is also liable to a criminal offense, so on and so forth. So you can have a look at these provisions. Also, if you falsely represent that your item is patented, that is also a criminal offense. I mean, it's only a fine of 1,000 rand. Just 1,000. But imprisonment not exceeding 12 months. So maybe that's the scare tactic. Very important note as well is whether to mark your product as patented or not. Okay. If you mark your product as patented, don't falsely represent that it's patented when it's only a provisional application or a pending application. There's no enforceable right until it is granted. It also needs to be accompanied by the official number. So what is the patent number? So it must be patented, ZA 2025 12345. Okay. What is the benefit? And this has come up in the exams. This is self-study, but it came up. What is the benefit of marking a patented product? Go for it.
I think it is to bring it to the attention of third parties that you have a right.
Exactly. It is notice to the third party that I am the proprietor of this. Okay. So you can claim damages from way back when they got access to their product already. Because you cannot claim damages for something that they were unaware of, not being patented. So they have to be notified that the product is patented. They must be aware of it. Okay. Guys, and with that, I think we come to the end at long last. Any questions before we head off?
Yes, sorry.
Online? Yes, okay, we've got some online.
With revocation, and I understood that indeed it can be brought as a counterclaim in infringement proceedings. Can you bring a revocation? Can a third party bring a revocation application without infringement proceedings. In other words,
Yes.
it's a standalone application.
Yes. So any party can at any time revoke the patent. There doesn't need to be, revocation is not just a defense on which you can rely on. You can actually just institute revocation proceedings from the get-go.
Has that happened in practice?
Often.
Okay.
It often happens because somebody might want to enter the market. They have the same product, they want to enter the market, so they will then try and get rid of that patent. So they will attack the patent on one of the grounds of revocation, on which it can be revoked.
Okay.
Okay, any other questions? Okay, if not, guys, then thank you very much. I really appreciate.
I'm sorry, I have
Yeah,
a few
okay.
questions, if you don't
Okay, we've
mind.
got a few questions. Yeah.
I just wanted to know, for the infringement claim, when the alleged infringing article is broken down into its integers and compared to the claims of the patented article, do all of the integers have to match up, or can it be just the sum of them? Or I'm a bit confused about that one.
Okay, so just don't confuse. There's a patent. You are the patentee. It's your patent. Those claims are then broken down into the integers. The alleged infringing article may not necessarily be patented. It's just an article or the product. So the court would need to assess whether that article comprises all of the integers in the patent claims. So the alleged infringing article needs to include all of the integers of the claim in order for it to be an infringing article.
Okay, thank you.
Okay. Pleasure.
I also wanted to know, this was just some stuff from yesterday, but in the notes in the textbook, the convention application is and in the legislation, the convention application is the one that's made in South Africa based on the application in a convention country. So is that the same as a national phase application, or are they different things?
No, they're different. So a national phase application is one that stems from an international PCT application. So it's followed the international phase. And then you need to nationalize within 31 months in South Africa, whereas the convention complete application that we refer to is one that is followed in terms of the Paris Convention. We are claiming priority 12 months after the application was filed elsewhere.
Okay. So when we refer to convention countries, it would just be those that have ratified the Paris Convention.
Yeah, that's correct.
Okay, perfect. Thank you.
Yes. Yes. Oh, you have another one. Okay, that's fine.
Okay.
I think that was all. I think that another question is just that if you could share with us the stuff that you drew on the whiteboard yesterday under section 31, I think it was 31.2, if you don't mind.
You give me
Thank
one
you.
second. There you go.
Thank you so much.
It's on the screen
Yes.
there, so maybe just take a screen grab of it. I'm hoping it will make sense to you now.
Thank you.
Okay, then I see Julia, you asking if the PowerPoint will be made available. It was already circulated to everyone by email. If you haven't gotten it, then please just let me know, because this is going to be one of your greatest sources for the exams to study from.
Yes, sorry.
Kaniso, yes.
I just want to test one thing from yesterday. In light of the explanation you provided on infringement, that the infringing article must actually infringe on all the integers of the claimed integers in the patent. Yesterday, when we were dealing with South African the provisional application and the complete application, the default position is that the priority date would be the provisional application, but there's an exception where In other words, you can't use your complete application date as the priority date. But the exception is that you introduce a what is it? A new integer into the, in other words, after you found the complete application, and then you introduce, before acceptance, you introduce a new integer for want of a better expression. And that introduction would then enable you to use the complete